There's something about the national interest waiver strategy almost no one talks about. It is, of all things, the calendar. Yes, the calendar. The average petitioner assumes a petition filed in 2026 gets adjudicated the same way, the exact same way as one filed in 2024, for example. They harbor a belief in temporal neutrality. The thinking goes, same legal standard, same framework, same resume, same case. That's not really how this works. World events that unfold can really affect cases, and misunderstanding this point quietly costs people strong, winnable cases, and that is sad. So sad. But before I go deeper, we should go over the NIW's legal framework. The cost to get the NIW, we call it a cost, is meeting the three-prong test from the 2016 case called Matter of Dinosaur. Prong 1. You have to show substantial merit and national importance of your proposed endeavor, your proposed work. Prong 2. You have to show that you, the petitioner, are well positioned to advance that endeavor. In prong 3, you have to show that on balance, it is more beneficial to the U.S. to waive the standard requirements, the job offer, labor certification requirements, than to keep them. All three have to be satisfied. Now, my focus in this video is on the way time, which we know, certainly I know, moves with a relentless indifference to our preferences, affects prong 1 and prong 3. Well, let me start with prong 1. Prong 1, it has two halves. The first half, substantial merit. The question is whether the work has real value. That's what the substantial merit inquiry gets at. Now, most petitioners handle that half just fine, but the second half, the national importance requirement, which is, does the specific proposed endeavor have national importance? That is the harder showing. It's where prong 1 denials happen, and it's where timing matters most. Now, most people, they treat national importance like it's a permanent label attached to the proposed endeavor. They say to themselves, an artificial intelligence proposed endeavor is important, period. That's what they think. They think that in itself it is important, divorced from context, divorced from what's happening, divorced from the calendar. I think my case with my AI proposed endeavor as it pertains to the first prong's national importance requirement is sufficiently strong. Well, they probably don't talk like that. That's probably lawyer speak, but I'm a lawyer, so I'll continue to speak like that. They think it's sufficiently strong this year and next year, or whenever I get around to filing. Well, that's not exactly true. National importance is often tied to timing. It's tied to what the United States government is paying attention to at the moment your petition lands on someone's desk. A clear example of this is actually from the Dinosaur case itself. That's the case I mentioned a few moments ago. The petitioner was an aerospace engineer, extremely accomplished, multiple graduate degrees, 2 masters, 1 PhD, all from North Carolina A&T. His research focused on hypersonic propulsion systems and computational fluid dynamics, with potential applications in nanosatellites, ballistic missiles, and single-stage-to-orbit vehicles. His proposed endeavor was to engage in research and development relating to air and space propulsion systems, specifically continuing his work on hypersonic propulsion systems and computational fluid dynamics. Strong profile. But here's what really powered the national importance argument in his case. Expert letters from individuals holding senior positions in academia, government, and industry describing the importance of hypersonic propulsion research as it relates to U.S. strategic interests. Media articles documenting the interest of the House Committee on Armed Services in the development of hypersonic technologies. Evidence of efforts and advances other countries were making in hypersonic propulsion systems, and the strategic importance of U.S. advancement. External context did much of the work. The atmosphere at the historical moment did much of the work. Documents related to that historical moment became evidence in the petition package. Had that exact same engineer with the same proposed endeavor and qualification submitted his petition during a period of profound national indifference, the path would have been steeper. Same engineer, same qualifications, different moment, different case. Let me give you another example. Take a hypothetical petitioner, call him Martin. All right, Martin works in petrophysics. He has a PhD in petroleum engineering. His proposed endeavor, developing a cost-effective workflow for evaluating shale reservoirs and disseminating it through published articles. Intended beneficiaries of the work would be U.S. energy companies drilling in the Permian Basin. They can't afford expensive evaluative processes. Imagine Martin filed for an NIW in 2022. The Biden administration then was emphasizing the renewable energy transition. Federal strategic documents frame the future of U.S. energy around decarbonization. Martin's work making fossil fuel extraction cheaper and more efficient for unconventional formations sat awkwardly within the administration's strategic messaging. Now, he could still argue national importance under prong 1, but he would have been swimming upstream. Now, imagine the same Martin. He files in 2026, different administration. The administration has reversed direction. Executive orders prioritize domestic fuel, fossil fuel production. The strategic framing has shifted to energy independence, domestic supply. Now, federal documents talk about reducing dependence on foreign energy sources. Martin's work simplifying unconventional shale evaluation, particularly for small domestic operators, is now squarely aligned with the federal strategic posture. Same petitioner, same PhD, same published research on simplified petrophysical reconnaissance. Profoundly different national importance cases because the policy environment shifted around Martin. The calendar matters. One of the pipelines from world events to immigration adjudication is actually surprisingly short. Something in the world happens, then the executive branch responds, an executive order gets signed, a federal strategy document gets published, a cabinet secretary gives a speech, a congressional committee issues findings, think tanks publish analyses, prominent newspapers reveal the government position in, off-the-record comments. And suddenly there's your evidence. There is your evidence to help support your national importance argument. Simple, this pipeline. It's mechanical. It works. But that evidence will have a shelf life. It is not immortally usable. Act on it. If the timing is propitious for your case, act on it. Make use of it. If the timing is good, there is a real argument for working with a lawyer who can put your case together strongly and quickly. The calendar, it matters. There's also a prong 3 dimension here. I said I would talk about the third prong. I did, so I am going to talk about the third prong. Prong 3 asks whether it benefits the United States to waive the normal job offer and labor certification requirements. Under DANISAR, USCIS may ask certain questions. One of those questions is whether the United States would benefit from the petitioner's contributions even if other qualified U.S. workers were also available. Timing matters here. The benefit a petitioner provides isn't fixed. It depends on the problem the petitioner is solving, and problems rise and fall in importance. The prominent newspapers, they chronicle a dilemma with feverish intensity, only to abandon the topic months later. Or congressional committees, they will convene their anxious inquiries. And then they'll redirect their gaze. Official strategy documents, they will identify a supreme national priority only to be supplanted, that priority be supplanted by a fresher one that reflects an entirely different set of anxieties later. See, the benefit of solving a problem at the moment when the problem is at the top of the federal agenda is meaningfully greater than the benefit of solving the same problem 2 years later when the agenda has moved on. The calendar matters. Another question USCIS uses to judge whether it benefits the United States to waive the normal job offer and labor certification requirements is whether the national interest in the petitioner's contributions is sufficiently urgent to warrant foregoing the labor certification process. Urgency is inherently time-sensitive. Contributions tethered to a problem the federal government identified recently as strategically urgent carries a very different weight on the page than the same contributions after the problem has drifted from urgency. There is a period of time during which the contributions have a glow. Make use of it by respecting the calendar. The calendar is not a side issue. The calendar, it shapes the evidence available to you. It shapes the framing available to you. Sometimes it shapes the outcome of a case. The petitioner who understands this isn't relying on luck. They're watching the movement of policy, government priorities, global events, and strategic funding, and understanding how those things flow directly into prong 1 and prong 3 arguments. That's real strategy, not just filing eventually whenever you finally think it's right or you finally think everything is in order. It's filing intelligently, filing quickly when the iron is hot. Here's the way to hold all of this together. Every petitioner has 2 clocks running. The first is the personal clock. Career goals, family considerations, visa expirations. The personal calendar, that drives most filing decisions. But there's a second clock. That clock is a policy clock or a world events clock. Which executive orders have been signed? Which strategic documents are current? Which cabinet statements are fresh? Which think tank reports are getting cited inside the government? Which crises are emerging? Which crises are hot? That is an important clock to pay attention to. Don't file when you're ready, whenever that may be. File when your evidence is hot and bountiful and meaningful. The corollary of that is more important though. When your evidence is hot and bountiful and meaningful, be ready to file quickly. Don't wait many months. I want that to sink in. The strategic petitioner files with the help of a lawyer often, so they can take advantage of a great moment. So if you want help building an NIW case around the moment, reach out. My law firm handles these cases every day. And we build great cases for talented folks. Contact information is in the description, and if this video is useful, subscribe, because more videos are on the way.